A very good evening to you. Many thanks for joining us. You're just in time for the big conversation on this particular day. I'm joined by Carolyne Kamende, the 49th Vice President of the Law Society of Kenya, who's also going to become the 51st President of the Law Society of Kenya, of course, succeeding the current President, Eric Theory. A very good evening to you.
Good evening.
Thank you very much for joining us tonight.
Thank you, and thank you for having me here.
Always a pleasure.
Thank you.
Okay, let's just get straight into it. I'd want us to begin with, there's been the ongoing tussle between the executive and the judiciary. From where you sit as a member of the bar, what do you make of the tussle between the executive and the judiciary?
Thank you very much, Keitani. I think the tussle and that altercation that has continued for so long between the executive and the judiciary is unhealthy and threatens to undermine the rule of law. I think to some extent also has taken away the independence of the judiciary and also how Kenyans in general view. So for me, that tussle was unhealthy. There are three organs of the state: the judiciary, the executive, and the legislature. Whereas all of them should work together, all of them are independent, and all of them are at par in terms of power. None of them that is equal. None of them is higher than the other one. So I feel from where I sit, and as a member of the bar, that continued altercation was unhealthy, and even the threat to disobey court orders by the executive is unwelcome, and is something that as members of the bar and even all Kenyans of goodwill should not allow to proceed. So from where I am sitting, that ought not to happen. One of the organs where the Constitution is specific on independence is the judiciary. There are two limbs or arms to this independence of the judiciary, one being finances, and that is why the Constitution establishes the judiciary fund. I think the drafters of the Constitution were clear that you can only undermine the independence of the judiciary if you interfere with the finances. And the other one is decisional issues. So those ones are well enshrined in the Constitution, and I think the drafters had foreseen this, what we have seen in the recent past.
Okay, yesterday the Chief Justice, Martha Koome, highlighted some of the issues affecting the judiciary, and top on the list was acute funding, and she also talked about the disregard of court orders by the state. As a member of the bar as well, is the state in order in disobeying court orders? Because we've seen even members of the Kenya Council Alliance trashing court orders, saying they're just papers. What do you make of that?
As a member of the bar, first, even as a Kenyan, I condemn that continued threat to disobey and actual disobedience of the court orders. Kenya is a democratic society. We've moved from the archaic days, the days where there was anarchy, where people would just do what they feel like doing. We are governed by the Constitution. And even as a member of the bar, if we are in a country where there is disobedience of court orders, where will we as lawyers earn our bread and butter? Because if I get a court order in a civil matter, I will not be able to execute. So continued or even the threat to disobey a court order will take this country to those old black days, and we should frown on the same. We should call it out, and we should ensure that it does not happen. Otherwise, we take Kenya back to the anarchy days.
Fair enough. Now, in your quest to become, the president of the Law Society of Kenya, of course, you've been the vice president. One of the key things that has been happening in the profession is, the barrage of fake lawyers. And apart from Wendwa, there was another one who was nabbed in Nakuru a couple of days ago. From where you sit, who is to blame for the rise in cases of or reports of fake lawyers and cases of impersonation? And probably, if you assume office as the 51st post, what do you aim to do, or what will you do to ensure that we stop this menace?
Thank you. this issue of fake lawyers, I think, stems way back to when the society started, maybe in 1948. But now we've seen increased number of masqueraders. We call them quacks or masqueraders from the society. It has continued. I will tell you, when I served as the vice president, I coordinated with the branches so we can try and weed them out. But now the problem is we have some of our members who have satellite offices. We have some of our members who have offices where they don't sit. They let secretaries and clerks sit. And that has increased this menace. And of course, the highlight was the Brian Mwenda, because Brian Mwenda was just not a masquerader, but he was deemed to be a member of this RUTO society. You'll be surprised that during the annual general meeting of this year, I think last year, he was there at the forefront, seated right there amidst us, and moving motions, opposing motions, and causing chaos and shutting down bona fide members of the law society. So this menace has been there, and it continues to go there, to grow. And I think another problem is because we are also many. We're increasingly becoming many. I'm lawyer number 5943, having been admitted in 2005. So if from 1948 to 2005, they only had less than 6,000. But now we are almost at 25,000 lawyers. So it's basically very hard for us to monitor as the law society. But this Brian Mwenda was an eye-opener, because this is somebody who was able to even impose his image and access our portal, which is sacrosanct. So this is where now I think every member of the society became alert. How to weed it out first is to ensure that we close those satellite offices that are opened by our members. If I have an office in Makueni and I'm never there, I leave my clerk and a secretary to man the office, they will be tempted to start doing work. And some of our court assistants, I will tell you, are smarter than even most of us, and they're smart. So I think to weed this out completely, the national office has to coordinate with the branches, because a masquerader or a quack in Nakuru will only be known by the lawyers who practice within that region. If I practice in Nairobi, I'm not able to know who is masquerading in Kisumu or Nakuru or any other town. So we need the support of the branches and the chapters and the centers of the law society that are organs of the law society to assist us in weeding these quacks. But I have said in my manifesto that I think we also need some inspectorate. We are allowed by the statute, that is our act that govern the society, the Law Society of Kenya Act. Specifically, Section 28 allows us to establish directorates. So we could, and I have a vision to develop an inspectorate, just the way the medical board does. They have inspectors that go around and weed out quack doctors. So we can have this as well, and liaise with authorities like the police, just in execution of the mission. But most importantly is to empower the branches. We need to revamp the branches and the chapters and the centers, because we already have our officials down there in the branches, the 8 branches of the Law Society. But the national office has to take lead, the buck stops with us. So this Brian Mwenda, of course, put the Law Society on the spot. Even as a candidate seated here, I really don't know how many Brian Mwendas are in the portal. Because if I'm able to access Lookuptv data, and I'm probably a stranger, how many more people can be able to hack that system and impose not only their pictures? Brian Mwenda not only imposed his picture, but he had now our peculiar number, the P15 number, fully endorsed in the system. So it is something that the Law Society members should now unite, and even members of the bench should assist us by making sure that people who appear before them, because the members of the bench are also our members, and they started on our side, to ensure that they also verify the people who appear before them advocating clients' cases. So one of the things that I would also ensure is to ensure that we have a list of all paid-up members and bona fide members of the Law Society circulated in the judiciary. The judiciary can also assist us weed out these quirks, because those who appear in court do not appear before fellow lawyers. They appear before fellow lawyers who are now members of the bench.
As a former vice president, how many times does the disciplinary committee have, its sittings? And because I believe this is the, body that is mandated with, dealing with such cases. That
body, the disciplinary committee, is not mandated to deal with fake lawyers. Mm-hmm. It is to regulate the conduct of bona fide lawyers who are guilty of professional misconduct. Somebody who masquerades as a lawyer, that is a criminal case. It's a criminal conduct. So it is, and that's why you saw Brian Mwenda being arraigned in court in Makadara. But now, back to the question, the disciplinary committee of the society sits once a month. I happen to have sat there because I was the vice president with experience of over 10 years in practice. The law allows any council member who is over 10 years of practice to sit there. But I will be sincere that I think and what I saw and witnessed was there's a lot of backlog. Cases do not move there. And I think we were most affected by COVID, because before then we used to have sessions at Professional Center, but it's just the first Monday of the month. I feel that is not enough to serve the members of the society who have complaints against each other, or members of the public who have complaints against our members. Nothing really moves there, and I must own and admit that even the days that I sat there, I witnessed, and I'm sorry to say there's so much backlog, and in one way, we are not serving justice to Kenyans who lodge complaints against our very own members.
For 30 seconds, if you assume the presidency, are you probably looking at a situation whereby, the sittings of that particular committee can be, upscaled probably?
Yes, because as I've said now, I have served there, and I've seen the number of cases that you'll have a long cost list, because it has been piling for over a month, and perhaps maybe the backlog stretches to 5 or so years or months, because at one time also we do not have enough members of the committee sitting, because they're supposed to have a quorum of 3. So we elect for some terms of other elected members of the committee expire, then we have to wait for the next election of the Law Society, which now causes quorum in deficiency. So I think I would look at it this way. If I was to assume office, inshallah, as the president of the Law Society, we can return back the physical hearings, one, and secondly, perhaps maybe do a normal cost list like the courts do normal cost lists every day, because I think the waiting of 1 month creates backlog, and the backlog continues to pile years and years and years. So I would be very keen on perhaps maybe bringing back the daily sitting of the committee, because I think if you're a member of the society and you offer to serve members in that board or that committee, you ought to be ready to be there on a daily basis. It's just like normal court proceedings that go on there. So I think the wait is unjust.
Okay, now, earlier on we talked about the tussle between the executive and the judiciary.
Yes.
And some of the grounds or allegations made by the president is that the judiciary is corrupt. But looking at it from all angles is that if the judiciary is corrupt, it cannot only be judges who are corrupt. There have been questions and allegations of corruption within the profession. So do you admit that there's lack of integrity among some quarters of the profession, and how do you plan to deal with that?
Thank you, but I don't think corruption is limited to the judiciary, to the lawyers, to the judges, to the clients. I think corruption is a national menace. But now, coming down to the judiciary, I wouldn't say in black and white that I know that there's corruption or I don't know that there's corruption, because I think most of these underhand deals or corruption activities are done in secrecy or in secret. But talking about the lawyers, we have an LSK code of conduct, what we call the SOPEC, that regulates our standards of ethics and how we conduct ourselves. And that SOPEC, LSK code of conduct, says that we should act or conduct ourselves with decorum. And corruption is one of the menace that can be picked out within that LSK code of conduct. But who prosecutes you? Because corruption is a criminal offense that is only prosecutable by ESCC. So on the part of the lawyers, the only thing that LSK can deal with is professional misconduct. And I don't think professional misconduct would be and can be termed as corruption. So if there is any corruption within members of the society because of the law society and the society general, that is a criminal offense that ought to be pursued through a complaint to ESCC and follow up in court as a criminal matter. So I wouldn't say that I would weed out corrupt lawyers, because members with complaints, members of the public or even members of the society with complaints against our members of the society are free to pursue the other avenue of ESCC, because as the law as it is, or our act as it is, the Law Society of Kenya Act and the Code of Conduct and the regulations do not have any provisions for the society to pursue anybody who conducts a criminal offense. That is left to the other arms or authorities that deal with it. But the only thing that I would undertake as a president of the Law Society is to ensure that all complaints of professional misconduct or any misconduct that is within the SOPEC that comes to the society will be dealt with by ensuring that there is efficiency and effective service of members in the disciplinary committee.
Okay, talking about the judiciary, the judges, members of the bar, the Supreme Court not so long ago did, of course, ban Lawyer Ahmed Nasir Abdullahi from appearing before the Apex Court, and it is a decision that even the LSK was against, and they appealed against it. What do you make of that decision? Do you think the Supreme Court made the right decision? And is it, an administrative decision that he made, or is it a judicial decision?
In my opinion, as an advocate, even as a member of the society, not the law society, but even a member of the public, the Supreme Court was extreme. There was an overreach on their side. What we saw was a decision that was communicated, and that is a decision I would call that was an administrative action. Any administrative action that has consequences that will infringe on anyone's right are supposed to be governed by the Constitution and the provisions of the law. The Supreme Court is a creature of the Constitution, and they ought to have followed the very body, the very Constitution that has established them to the latter. I condemn in the highest terms possible that action by the Supreme Court judges to deny audience to Senior Counsel Ahmed Nasir. It was wrong, it is illegal, we need to call it as it is. It is unconstitutional. His rights are guaranteed under Article 49 and 50. He ought to have been given a fair hearing before a decision that was reached. We saw none of that, even if we were to argue that he was perhaps given a warning. A warning is not a hearing. Secondly, we saw a blanket condemnation of his law firm, the Senior Counsel's law firm, and the associates. How were these associates condemned and heard as well. His law firm, does that mean that his law firm will never serve any clients in that court? From where I sit, I refuse to buy the notion that this is a decision that was judicial. This was an administrative action that is challengeable under Article 165 of the Constitution. The High Court has original jurisdiction to determine and deal with matters that infringe or threaten to violate the rights of an individual. So, as a member of the bar and as an advocate, this is a decision that we should not allow to go on, because having come from the apex court, that means that the other courts will follow suit. Anybody 20 years, 30 years from now will tell me, Carolyne Kamende, you will not appear before me together with your associates. Where will you go? So we need to quash and have this decision declared illegal and unconstitutional, because that is what it is. It was draconian, it was very drastic. Even assuming that the Supreme Court was exercising its power within Section 18 of the Supreme Court of Kenya Act, they cannot have given an open-ended bar of audience to Senior Counsel Hamed Nasir. That section allows the Supreme Court to deny audience to an advocate or a member of the public, audience before it for a period not exceeding 18 months. What informed their decision to give him an open-ended bar? It is wrong, and it should be called wrong because it is wrong.
Well, fair enough. There are three sections. There's the young bar, the middle bar, and the senior bar. What are the challenges facing members of the bar, and how do you plan to go about, the challenge they face to ensure that, things are streamlined?
I will say that I don't know whether I'm a medium or I'm in the middle bar, because I have practiced. This is my 19th year in practice, but I'm running on a mantra of an inclusive bar, because over the years we've seen segmentation. At one point, I called myself a young member of the bar. We even had some outfit called TIBA, that is the Young Lawyers Bar Association. We recently also saw the senior bar have their own dinner. So the challenges that face the society, first I will say, are the same, only that the younger bar, because they are more, and because we keep having them admitted to the role of advocates every year, and nowadays we churn them in many numbers, is unemployment. We have limited areas of practice, or we have limited space or cases, because we are many now. We're running up to around 25,000. But the challenges that are common and universal to all of us is diminishing spaces of practice of law. Like you recently saw the Honorable CJ say that Huduma centers can handle our work. You see, that is a challenge, or that is a problem or a menace that will affect a member of the bar who has practiced for 50 years, or the one who has practiced for 0 days. So that is one challenge that cuts across. Of course, masqueraders, quacks that I spoke about earlier, affect all of us, because they undercut, and there's quick monies, there's quick services offered to members, to our clients, by quacks. That is also a universal problem that cuts across all the segmentation of the bar. But peculiar to the young bar is now unemployment, because we no longer have that policy. We used to have a policy, or it was actually in the statute. It was a statutory requirement that any member of the bar admitted must practice under somebody, a senior member of the bar, for 2 years. Once that was removed, now our younger members of the bar are exposed. Like, you get admitted tomorrow, where do you go? You don't have money maybe to start a practice of your own. So that is a challenge peculiar to the younger bar, but also it doesn't mean that all is well for all of us, regardless of the number of years that we've practiced. How we need to do that is to protect our areas of practice, and that is one of my agendas. My core agenda is to have our areas of practice. I filed as a petitioner, Carolyne Kamende as a petitioner, the case that is in court challenging the taking over work by the judiciary and the executive in the partnership of having legal services offered in the Huduma centers. So once elected as a president, if God willing members elect me, I will endeavor to ensure that we monitor legislation. I was in a council that monitored legislation to ensure that the small claims then was a bill did not take away work that is supposed to be done by lawyers. So I will endeavor that we protect our practice areas through expanding the environment one, and also ensuring that we monitor legislation to see what policies, directives take away our work. When Honorable Paul Kihara was serving as if I'm not wrong, as Attorney General, there was a directive that was passed that said that public institutions, I don't know whether it was Honorable Paul Kihara or Githu, Prof, that said that we cannot be outsourced as external lawyers by public institutions. We quickly went to court and quashed that directive. So my mandate would be, if elected, to monitor all policies, directives from whatever arm of the government that come to take away our work. And that way now we will have our lawyers and our members having more opportunities and having spaces to practice law.
Having served as the VP for, the 2 years under
2 years
under one Nelson Harvey.
Yes.
What is that one thing that at the moment you feel like was not implemented then, that if you're elected as the president of the Law Society of Kenya, you will make sure it is implemented?
Thank you. We took office under very, very hard times. COVID struck just a few days after election to office. And then I had run on a mantra of welfare fasts. So between, I think, February and March, before COVID struck, we had admitted, the CJ, the Honorable Chief Justice Maraga, had admitted almost 1,000 lawyers. And I happened to have been in the groups of all these 1,000 lawyers, because they just used to add me to their groups when they were at Kenya School of Law. And now, having run on that mantra of welfare fasts, the weight was on my shoulders. Where do these members of the bar go? Where do they get their daily needs? Given that now courts were closed, movement was restrained, and we were not moving. So I quickly came up with a scheme, care packages for lawyers. I partnered with supermarkets, and the senior members of the bar and even members of the bar, regardless of their cadre, would send me bonga points and money, and I would redeem at supermarkets and send vouchers, shopping vouchers, to our members within the country, because there was no movement. The movement was limited. But when I went back to council, I now realized that it was not possible. This was not a sustainable scheme, because in case of such an eventuality, in case of such calamity ever hitting us again. So I established an endowment fund, an emergency and endowment fund, with trustees taken from the senior bar, the Law Society of Kenya president, the vice president, the secretariat, a convener of the young bar, who sits in council, and a member of the young bar, and I think those were supposed to be the trustees. But we got some seed money of 500,000, but I was unable to complete this endowment fund because our term came to an end. So that is one activity that I would want to establish on my day one, complete it and ensure that it is operational. A kitty that we can all look back to and fall back to as members of the society if we are at that extreme vulnerability. Secondly, during the commemoration of Willie Kimani, I convened a committee of the Law Society called Lawyer, Police and Other Authorities Committee. And I figure out if Willie Kimani, for example, had had a toll-free line to the Law Society. Perhaps this time he was writing a note on tissue paper and throwing out to a motorbike person by the time they pick. Perhaps maybe if that stranger who picked that note had called the Law Society, maybe would have salvaged our member. So I partnered with Safaricom. The Law Society of Kenya procured emergency lines free of charge, toll-free lines. We launched them during the Katiba Day of 2021. And there were only 9 for the 8 branches and 1 for the national office. Those I will intend on my first days as the president of the Law Society, if elected, to relaunch them, to sensitize members, and not only roll out to the branches, but also roll out to the chapters and the centers, so that we have our members in distress know that there's a line, there's an emergency line that you can call the Law Society, and the Law Society as your body will protect you and perhaps maybe come to your rescue.
We're really running out of time.
Yes.
But it would be unfair for me if I didn't give you this platform. I'll just give you a minute and a half to vouch for yourself. Why should members of the bar appoint you as the next president of the Law Society of Kenya?
Members of the Law Society, I plead that on the 29th of February 2024, you vote me, Carolyne Kamende Daudi, as your next president of the Law Society. I have served the Law Society before in 2 capacities. Between 2018 and 2020, I served as a Nairobi representative. It was during that tenure when I convened the Gender Committee and came up with the first ever sexual harassment and anti-bullying policy. Between 2020 and 2022, I was the vice president. I ran on a mantra of welfare first, and I literally carried the weight of the lawyers on my shoulders. I established, like I've said before, 2 permanent structures in the Law Society that will ensure that we have taken care of the welfare of members. On the rule of law, I stand, and I have been there when we have stood and defended the rule of law and constitutionalism in line with the provisions of Section 4 of the Law Society of Kenya. I've already said that my sole agenda will also be to protect the practice spaces that we have, to ensure that they do not diminish. Without quacks and masqueraders, people are invading into our spaces. Of course, I have also indicated in my manifesto that I will ensure that there is accountability and transparency in the management of the affairs of the Law Society, and also efficiency in the way we serve our members at the Secretariat. So I would request the members of the Law Society to kindly consider me as their next president on the 29th of February 2024.
Thank you very much for joining us this particular night. All the best in the upcoming elections, which will be held on the 29th of February 2024. Well, that was Carolyne Kamende Daudi, the 49th Vice President of the Law Society of Kenya, and she's going to become the 51st President of the Law Society of Kenya. She currently serves as the President of the African Bar Association Kenyan chapter. Of course, she'll be battling it out on the 29th of this particular month to, of course, succeed one Eric Theory. That is all that we had for you at this particular moment in time. Thank you very much for joining us tonight. Do have yourself a wonderful night, and like always, God bless.